Good day. My name is Jackie Sunde. I'm a researcher at the One Ocean Hub research team at the University of Cape Town in the Department of Environmental and Geographical Science. I'm really privileged to be here with you today and to share in the celebration of Ocean Week. It's particularly significant for me because the community whose story I'm going to be sharing with you today believes that the ocean is our great home. It is the source of life, and it's the place where many of their ancestors reside. I'm going to be sharing my screen with you now for the presentation. Please bear with me for a minute. In the first part of the presentation, I'll be tracing some of the approach to customary law by the colonial authorities. And in the second part, I'll be presenting the case of the Drizzt communities on the eastern seaboard of South Africa, who have been the first community that's used a customary law defense in order to claim their fishing rights. In South Africa, archaeological, material, and ethnographic evidence attests to the importance of the marine and coastal space in the histories and cultural ecologies of coastal dwellers in pre-colonial and colonial times, and the expression of distinctive patterns of marine resource use and tenure, finely woven into social organization, cultural and economic relations, is still visible along the coastline. Like many indigenous and local coastal communities in colonial contexts around the world, customary rights to marine resources, including sea territory, are embedded in the customary laws of those communities. And the recognition of these customary rights, resource rights, is thus closely tied to this recognition of customary law. However, in South Africa, as in many colonial and post-colonial contexts, customary law has struggled for recognition alongside the law of the colonizers. In most instances, colonial regimes have subjected the indigenous communities to the law of the conquering power. And as Cordella's noted in the context of the Pacific, the struggles for recognition of their customary marine rights in law is for many indigenous peoples essentially a struggle to reconcile legal interests in collision. As a result of its Dutch and British colonial history, South Africa has inherited an extremely complex legacy of interacting systems of law. In 1652, the Dutch took occupation of the Cape of Good Hope at the southwestern tip of Africa on the western seaboard, on the Atlantic Ocean side. And it's recorded that the very first governor in his diaries, just 3 days after his arrival, noted that he'd issued an edict prohibiting throwing of nets and fishing by the indigenous Khoisan peoples without his permission. And in the subsequent years, regulations were introduced to ensure that any fishing that was done was aimed at supplying the growing Dutch settlement at the Cape. And this is the first example of the sort of control of marine resource use that we see in the Cape. In contrast to the indigenous Khoisan peoples of the Cape, the indigenous African peoples on the eastern seaboard of the country did not fall within the reach of the Dutch colonial authority and continued to fish according to their customary systems. However, following the English occupation of the Cape, initially in 1790 and then permanently from 1806, the English gradually began to push eastwards, coming into contact and conflict with the Amaxhosa peoples of this region. The colonial government imposed a Western colonial perspective of what constituted law and authority, especially in relation to rights in land and natural resources. Initially, an approach of direct rule, which aimed to weaken the power of the chiefs, was embarked upon. However, this shifted over time to a hybrid policy of direct and indirect rule. The colonial administration asserted the political legal authority of the chiefs as recognized rulers over their people. And this interpretation of customary law fundamentally altered the basis of authority of the chiefs in customary law. Power was now vested in the chiefs, whereas previously it had been vested at a local level amongst family and lineage elders. And they interpreted African societies' rights in land and natural resources through the same Western legal lens and notion of property and rights. And individual property rights were seen as the measure of civilization, and collective or communal rights were misconceptualized as weaker rights. And the colonial authorities recognized customary law on an ad hoc basis, and only when it was not repugnant to civilized standards. In 1918, we've seen the British Judiciary Privy Council ruling in relation to Southern Rhodesia, and I think it was this attitude that certainly influenced the empire prior to this. In the Privy Council judgment, it was stated, "Some tribes are so low in the scale of social organization that their usages and conceptions of rights and duties are not to be reconciled with the institution or the legal ideas of civilized society. Such a gulf cannot be bridged. It would be idle to impute to such people some shadow of the rights known to our law, and then to transmute it into the substance of transferable rights of property as we know them." And although spoken some years later in relation to Southern Rhodesia, we can imagine that this attitude was prevalent, and it's persisted over a century in Southern Africa and has led to the subsequent distortions and colonial codifications of customary law, the vestiges of which remain in approaches to property rights in some contexts. It continued in this race legacy of colonialism, which shaped how statutory and customary systems interfaced along the shores of the country in the apartheid period. The Native Land Act of 1913 restricted native ownership to particular areas of the country and essentially restricted African people to only 13% of the land. The Native Administration Act of 1927 further consolidated this, as did the Bantu Authorities Act of 1951. And through the Bantu Authorities Act, the authorities or the state aimed to define a distinctive administrative and legal domain for African people through implementing a policy of separate development. They were able to establish what was known as the African homelands, or came to be known as the Bantustans. The authoritarian chiefly powers were boosted in these homelands, and customary law was only recognized insofar as it pertained to the domain of African affairs within families and African communities. Here on the map, particularly on the eastern seaboard of the country, you can see in the colored pieces, the colored lands, the various homelands that were scattered particularly in the eastern and in the northeastern regions of the country. As a result of the history of colonialism and apartheid, South Africa inherited an extremely complex legacy of interacting systems of law in 1994 at the transition to democracy, when the first democratic elections were held. Can you believe that at this time, more than half the population still lived under some form of customary law? These different legal systems have interfaced historically, both shaping and being shaped by each other. And the successive layers of distortion from these governance regimes and the narratives of legality that it gave rise to has left a deeply contested sea of laws. In 1996, the new South African Democratic Constitution recognized customary law as an independent source of law, norms, and rights. Section 39 recognizes the rights and freedoms conferred on persons under customary law insofar as they are consistent with the Bill of Rights. And this was an incredibly radical departure, because prior to this, under colonialism, customary law was limited to regulating relations and disputes within African communities only, and it didn't have broader reference to other legal issues such as customary rights to property and natural resources, including the sea and marine resources. Subsequently, Constitutional Court jurisprudence has seen the emergence of a number of principles that have been key to establishing the content of customary law and that are helping to unshackle it from its colonial and apartheid distortions. And several of these principles have now become part of South African law through this transformatory constitutionalism. We've been extremely fortunate to have some brilliant constitutional lawyers in the country who've really taken this forward. In the case of Richtersveld, the court ruled that the content of living customary law must be determined with reference to both the history and the usage of the community concerned. In this case, it highlighted that living customary law is the term used now by the Constitutional Court in South Africa to refer to customary law that is actually observed by the people who created it, as opposed to official customary law that is seen as the body of rules created by the state and the legal profession. A number of other cases have helped to further explain the nature of the evidence that is required to prove customary law. The validity of customary law is determined with reference to the Constitution and not to common law. And customary law must be understood on its own terms and in its own setting. Significantly, the Constitutional Court has also indicated that the Constitution does provide for the statutory regulation of customary law, mindful of codifying or putting into a rigid codification of customary law, which is obviously not appropriate, but such regulation would only amount to the extinguishment of the customary law right if it was done explicitly. So there's been considerable development in the law, and this has come primarily from the Constitutional Court. But on the other hand, the legislature has been very slow to change and be transformed with regard to its approach to customary law. And it's continued to develop statutes which are largely silent on customary rights or undermine collective rights implicitly. I'm now going to turn to the case of Drizzt, a community called Hobeni within the Drizzt communities and their living law of the sea. The ancestral lands and waters of Drizzt were settled by this community's ancestors several centuries ago. In their customary system, the land, the forest, and the marine resources are considered communal property. Harvesting, catching, consumption of, and local trade in marine resources extends back to their ancestors having settled this land. And since time immemorial, their customary practice has been to utilize the sea and its resources in order to feed their families, to cleanse and heal themselves, and to perform certain rituals. Here again is the map, just to draw your attention to Drizzt. You'll see the star on the eastern seaboard in the orange shading. The community's relationship with this land and the sea, derived through their relationship with their ancestors, is reflected in their cosmology and the relational ontology that shapes their culture and their customary tenure system. As I mentioned at the beginning of the presentation, for them, the sea is their great home. It's the source of life, and it's where ancestors reside. And this approach is reflected in their relationship to the sea, to the land along the coast, and to each other. They believe that they belong to this land. They say we are born with these sea creatures. For them, belonging to the land is unlike any Western concept of ownership, which talks about land belonging to people. Here, they believe they belong to the land and the waters. Here you can see some of the traditional harvesting practices and fishing along the coast. The nature of living customary law of the sea in Drizzt is quite distinct. Rights arise through membership and residence of the local group whose ancestors settled this coastline. Individual and household rights are layered, they're nested within the collective rights of the group. Decision-making is vested at local level, and dispute resolution is processual and distributive. Customary law is woven into the social fabric of local governance and social relations. It's not seen as a separate juristic domain. The African ethic of Ubuntu informs customary rights and obligations. The ethic of mutuality and reciprocity underpins social relations. Local ecological knowledge is transmitted down through the generations through specific rituals and customs. And here in the picture, you can see one of these rituals where all the families and households in an area combine to contribute their labor to the building of a particular structure that is used in one of the rituals that help to initiate young men into manhood. Over the course of a century, the 7 communities comprising the Drizzt area were dispossessed of their land, their forest and marine resources in the name of nature conservation, with devastating consequences for their basic food security and livelihoods. In the early 1890s, some homesteads were initially dispossessed by the British Colonial Forestry Office that wanted to get control over the beautiful coastal forests, and these homesteads were moved inland several kilometers away from the coast under the guise of conservation. The forest was closed to them, and subsequently a hotel was built for white traders and white holidaymakers on their land inside the coastal forest reserve next to the beach. The apartheid regime established the Transkei and Bantustan in 1957. Subsequently, South African marine scientists worked closely with the Bantustan authorities here to extend the conservation estate along the coast by declaring marine reserves and protected areas. The Drizzt Nature Reserve was declared in 1975, extending the much earlier forest reserve to include the shoreline, the rivers, and the estuaries. And the area was subsequently fenced, and alien and exotic wildlife such as crocodiles and rhinos were brought into the area. The community was further dispossessed of their land. Many of them were moved further out. Their access to the sea was restricted, but they did continue to fish on a subsistence basis. However, the area became very sought after by white recreational and sports fishers who were allowed to fish and who stayed at the hotel inside the reserve next to the sea, with the community on the outside, on the margins of the reserve. In 1994, with the coming of democracy to South Africa, the community started negotiations for the restitution of their rights with a range of national and provincial authorities. These authorities included the Department of Environmental Affairs and Tourism. The communities argued for sustainable use of marine and forest resources, and the authorities agreed to this. However, a very powerful conservation lobby in the country argued that the nature reserve should remain under conservation authorities in the interests of the common good for all South Africans. So in June 2001, when the land claim settlement agreement was signed, it was agreed the community's restitution of their land was recognized. They would get co-management rights over the reserve. However, the reserve would remain a reserve, and the communities would get access to and use of resources on a sustainable basis. 6 months prior to the community signing the settlement agreement at a great significant affair with many heads of department and government officials, including the former President Jacob Zuma, without any consultation and without the community knowing, the Department of Environmental Affairs and Tourism went and declared the Drizzt Reserve a marine protected area. Significantly, it was also to be a no-take marine protected area. However, the community was not aware of this at the time when they signed their land settlement agreement. The actual enforcement of this new no-take, no-fishing status only came into being sometime after their settlement agreement was signed, and immediately arrests, prosecutions, and criminalization of community members who went fishing followed, because the community depended on this coastline and the forest for their food. In 2010, 3 local fishermen, David Malibongwe Gongqose, Sipumla Wundasi and Kosipendula Juza were arrested for fishing inside the marine protected area. They sought legal support from the Legal Resources Center, a human rights litigation organization, who agreed to represent them. And in 2012, they pleaded not guilty in the Rural Magistrates Court of Elliotdale. This is a very significant case because it's the first time that a customary law defense has been used in the South African courts, drawing on the constitutional recognition of customary law. They were charged in terms of the statute, the Marine Living Resources Act of 1998. However, they argued that they'd been fishing according to their customary system of law, and hence this should be permitted. You can imagine a small rural magistrates court in the former Transkei Bantustan area, where prior to this, fishers who'd been arrested had never had legal representation previously. Here in this little court, in March 2012, we saw Western positivist law come up against living customary law in the state versus Gongqose and two others. It really was an act. It was two different types of law, different ways of viewing and ordering the world coming up against each other. The community entered a plea of not guilty at the onset of the court case and said that when they were arrested, they were intending to fish according to their customary rights. I wish I had time to describe to you the way in which the white state prosecutor approached this case. However, suffice it to say, given our time constraints, that we saw two very divergent systems of law embedded in alternative ways of knowing and being with different logic and sources of authority really coming up against each other. The sources of authority was interesting. The community had asked one of the local women who is a Sangoma, or a traditional healer in isiXhosa, to come and give evidence that at times the ancestors call them to the ocean where they perform certain specific rituals. You can imagine the horror on the face of the state when the community said that, the community witness, Vuyelwa Sialeko, said that at times the ancestors instruct her to go to the sea and perform a ritual. He turned to her and he said, "The who instructs you to do what?" in a very derisive manner. The community's communally oriented system of law, embedded in materiality of rights arising in terms of their social relations and obligations, was pitted against the individual, narrow, statutory rights-based logic of the state. The community presented evidence of their customary rights arising from their customary system of law. The defense drew on international law and Canadian and Australian jurisprudence on Indigenous rights to resources, while the state actually drew on English law. Literally, the state said to Mr. Gongqose, "Do you know about English law?" and summoned up notions of right and wrong law in their cross-questioning him. Continually ask him, did he understand the difference between right and wrong? In his judgment, the magistrate, Honorary Magistrate Nell, said he was forced to find the community guilty in terms of the statute because the Marine Living Resources Act was applicable. However, he added that whether the provisions in the Marine Living Resources Act are constitutional is debatable, to say the least, and he encouraged the community to take this case to a higher court that would have the authority to determine the constitutionality of the provisions in the statute. In 2016, the High Court in Mthatha ruled that the community of Drizzt had a customary right to fish, and in 2018, the Supreme Court of Appeal confirmed this ruling. This marks a sea change in the recognition of rights and the governance of marine resources along the coast of South Africa. untethering communities whose access to marine resources forms the material basis of their cultures and their livelihoods from the shackles of colonial law and governance. Challenges do remain as recognition demands a substantive paradigm shift for government and enforcement officials. However, an important step has been taken in decolonizing the legal system and beginning to constitute plural ecologies of knowing and governing the human nature of our ocean. Thank you. Special thanks to the Hobeni community of Drizzt for permission to share their story with you, and to David Wilson from the One Ocean Hub for making this possible.